helpful advice regarding the subject matter of this presentation, you should consult with your own attorney. Collection laws vary from state to state in how they are applied and interpreted. Nothing in this educational presentation shall be deemed an endorsement of any products or services offered by any company. And with that, I'm going to hand it over to Chris.
Well, thanks, Adrienne. I appreciate the invite to speak to everybody, and thanks for the great introduction. I'm flattered, and again, thank you for all attending, and thanks for inviting me. Just briefly want to go over some emerging technologies and how collectors can use them compliantly during this presentation. So essentially, summary of it will be the type of technologies, how the FDCPA applies to those technologies, and then how to use these technologies, in a complicit manner. So the emerging technologies, through the use of these emerging technologies, debt collectors can communicate more effectively with their debtors. Generally speaking, though, the same old rules apply. Debt collectors should be allowed to use all communication technologies, including new and emerging technologies, to contact consumers. But as always, the law must be carefully adhered to, and in order to avoid collectors' use of communication technologies in a manner that causes the debtors to incur charges and the subject debtors to unfair, deceptive, or abusive acts and practices, or otherwise subject collectors to violations of the FDCPA, and that's the Fair Debt Collection Practices Act. So in summary on that one, in using these, you still have to adhere to the same rules, so you can do it within the confines of the law. Next slide, please. So there may be a tension between new communication technologies and the FDCPA's requirement that communications concerning a debt not be disclosed to third parties. Let's move this over a little bit. However, the FTC is not aware of any credible evidence suggesting third parties have greater access to debt collection messages conveyed through these methods than through letters or telephone calls. And what that basically says is that the FTC did, I don't know if you'd call it a study, but they looked at some emerging technologies, and they discerned that they really aren't, they don't know if they're any more effective in the old technologies, but they don't think that they are any more apt to disclose the debt, the communication to third parties. So nevertheless, the Commission emphasizes that if a debt collector reveals the existence of a debt to a third party through any method, including email and instant messaging, the collector is and should be liable for violating Section 805B of the FDCPA, and we'll get to that in a minute. Adrienne, next slide, please. So broadcast message technology. This delivers messages to answering machines and or people in an automated fashion. It's a very broad term, but that's the use of, that's what it means to deliver massive amounts of messages. Delivers consistent messages to your target audience, and it's an efficient way to deliver mass messages quickly. Next slide, please. So here's where we'll get into the meat of it a little bit. This is, as I'm sure anyone who's versed at all in the collection industry is familiar with this act. It's the Fair Debt Collection Practices Act. It was passed in the early 70s, and it was passed in a measure, as a reaction to some, very unlawful, what would be considered unlawful now, collection practices. And it basically curtails what collectors can do when collecting a debt. Generally speaking, the law only applies to third-party collectors, meaning those collectors who are collecting on debts that are not theirs, not first-party collectors, which are collectors that are collecting on debts that are their debts. However, generally speaking, it's good practice for anybody in the industry or anybody engaging in collections to adhere to the FDCPA. Many different states have adopted similar versions to the FDCPA, some more stringent, and some of those states do cover first-party collectors. So always a good idea to follow it, whether or not you're first or a third-party collector. Section 692(c) states, without the prior consent of the consumer, given directly to the debt collector or the express permission of a court of competent jurisdiction, a a debt collector may not communicate with the consumer in connection with the collection of any debt. And then it says, at any unusual time or place, if the collector knows the debtor is represented by an attorney, or at a debtor's place of employment if the collector knows the debtor's place of employment does not allow collection calls. The unusual time, that's been construed between the hours of 8 a.m. and 9 p.m. And as far as the debtor's place of employment, if you're told not to contact the debtor's place of employment, you shouldn't do that, or you otherwise know that their place of employment does not accept calls for their employees, or does not accept collection calls, then you should not call the debtor's place of employment. Next slide, please. 1692B of the FDCPA, this is the prohibition of disclosing a debt to a third party, and I'll tie this into another portion of the FDCPA where there's a little bit of conflict. But this says a debt collector may not communicate in connection with the collection of a debt with any person other than the consumer, his attorney, a consumer reporting agency if otherwise permitted by law, the creditor, the attorney of the creditor, or the attorney of the debt collector. So basically, this is saying you cannot disclose the existence of a debt to a third party. Next slide, please. And this is another portion of the FDCPA. 1692E states a debt collector must disclose in the initial written communication with the consumer, and in addition, if the initial communication is oral, in that initial oral communication that the debt collector is attempting to collect a debt, and that any information obtained will be used for that purpose. This is otherwise known as the mini Miranda, and this is where a little tension exists between the non-disclosure of third parties versus you're having to disclose the purpose of the call to the debtor, or the purpose of the communication. And again, this is known, as many of you I'm sure know in the industry, the mini Miranda requirement. Mini Miranda is a little play on the Miranda warning that the police must give if they arrest anybody in the U.S. That was based off an Arizona case, but anyways, they tied it into the mini Miranda into the FDCPA. So that's next slide, please. Now, the FDCPA also has rules having to do with ceasing communication with debtors, and we'll talk a little bit about that. 1692C states, if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes a debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt. If a consumer requests in writing that the debt collector cease contacting them, the collector must comply. Now, that's been construed to be in the form, generally speaking, of a letter saying, hey, I'm Bob Smith. I am formally requesting, debt collector, that you cease communicating with me regarding my debt. We'll get to this in a minute. We don't think that a debtor responding to a text saying stop would constitute sufficient written notice to a debtor to entirely stop communicating with them. I think if somebody responded stop to a text message, a collection text message, I think you would have to stop sending them text messages, but we'll get to that later on in the presentation. Next slide, please. So more about the FDCPA. 1692 states a debt collector may not engage in any conduct with the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section: causing the phone to ring or engaging any person in telephone conversation repeatedly or continuously with an intent to annoy, abuse, or harass any person at the called number. This is the part of the FDCPA that basically says, you cannot continually contact a debtor in an abusive manner. Now, that does not mean certainly that collectors cannot contact debtors. Obviously, they can. But what it does mean is that you want to limit how much you contact the debtor and what is considered reasonable. There's a case out there, and it's outlined below, Professional Recovery Service, and it allowed for 1 to 2 unanswered calls a day in an unsuccessful effort to reach the debtor. If this effort is unaccompanied, not including any intent to annoy, harass, or abuse the debtor. So, long story short, you can make a couple of calls a day. Probably to be on the safe side, 1 call a day would be good. And same goes with an SMS text. Anything over 1 or 2 per day, you may be in the territory of a debtor, having a cause of action against you as the collector for a violation of this part of the FDCPA. Next slide, please. So these are some things to consider when developing your voicemail message, your collection voicemail message. Are you going to use a press 1 to speak to a live collector? Do you know the number you are calling the collector on? Is it a home, work, or cell? Because as we discussed with the work number, if you know it's a work number, you need to know, or you need to have an idea of how their employer views calls, or if they allow calls. Does the technology allow for scheduling of message delivery? So you'll know how to word your message if it does. So you need to be prepared for that. And do you know what time zone you are calling into? This is important because, as we know, we can't contact a debtor after 9 p.m. So, with cell phones, you can easily, with any phone number, you can easily look at an area code and see which time zone it falls into. But the problem is with cell phones, people can be out of their area code, or in some cases, people can move out of their area code and just never change their number. But again, I think you could have a really, really good defense, or a very strong defense, to any debtor that brought an action against a collector claiming they contacted them after 9 p.m. If in fact their area code said that said that it was not past 9 p.m. So anyway, that's just something to think about. Now, the collection voicemail, this is recent case law. It's a case called Fody that came out, and we'll get to that in a minute, suggests that you leave this on a voicemail. So when you're leaving a voicemail for a debtor as a collector, you need to state the name of the collector's employer, the fact that they are a debt collector. You need to give the mini Miranda that we just discussed, and I'll give you a specific message to leave in the next slide or two. And so you need to do those 3 things to comply with Fody. And that's the case that came out that raised these issues. Next slide, please. So here's a sample voicemail that you can leave, and this is from I believe this came out of an FTC publication. So, but I'll just go ahead and read it to you, and as if I were leaving the message. So, the voicemail picks up. This is a message from Mary Smith. If you are not Mary Smith, please delete this message. Pause momentarily. If you are Mary Smith, please continue to listen to this message. Ms. Smith, you should not listen to this message so that other people can hear it, as it contains personal and private information. There will now be a 3-second pause in this message to allow you to listen to this message in private. And you pause for 3 seconds. By continuing to listen to this message, you acknowledge you are Mary Smith. This is Bob Jones from ABC Collection Agency. This is an attempt to collect a debt, and any information obtained will be used for that purpose. Please contact me about an important business matter at, and you leave your phone number. So that's a compliant voicemail nowadays. In the past, in not so recent past, I guess pre-2009, you would never leave a message like that. I digress a little bit, but I was in my undergrad. I was a collector for a bank, and I was a first-party collector. But we never would have left that kind of information on a voicemail back then. You just said, Ms. Smith, this is Chris Meier with such and such bank. Please give me a call back. So, it's just a great example of how the law is always evolving. And had you left a message like that in the past, you would assume you'd get a lawsuit, 10 days later. But things have changed. Next slide, please. So to go back kind of over the details of that voicemail, the message comports with a warning and pause to allow a non-debtor to cease listening to the message. So that's the part of the FDCPA 1692 that says you're not to communicate the debt with a third party. Well, the rationale is the pause saying, if you're not Mary Smith, you need to hang up the phone. We'll give you 3 seconds. This sort of says, okay, you're not disclosing the debt to a third party because presumably the third party should hang up the phone, or at least you can have a defensible position saying they should have hung up the phone if you're ever, if anyone ever questions you over it, or you're ever, involved in a lawsuit over such a message. And again, there's the warning to alert the consumer, disconnect the call, listening to the message with others nearby. There's a case to support that. And there's the meaningful disclosure of the collector's identity, including the name, employer, and phone number. That's the mini Miranda. Next slide, please. So going back to FODE, that was a lower court decision, is only really only controlling in its respective jurisdiction of New York. Any court cases that come out in any states, even in the state Supreme Court, is really only controlling on that state, or on that state's courts, pardon me. However, as with any case law, other courts may choose to follow the ruling when faced with the same question pertaining to messages left on answering machines, and may be very inclined to do so in the absence of case law to the contrary. So if there's no opposing case law saying the opposite, they're likely to follow that. Also, being that it comes out of New York, that's a very strong jurisdiction. There's also a very similar case in California. So between California and New York, if that's the prevailing trend as far as leaving a message goes for a collector to a debtor, then it's probably best to go with what they're saying. Next slide. So now this has to do with mobile messaging technology. This gets into SMS text. SMS stands for Short Message Service, and it sends text messages via mobile phones, either via a one-way SMS text or via a two-way SMS. The SMS blasting function allows you to schedule messages to be sent immediately or in the future. So mobile messaging is becoming the communication of choice to stay in touch. By adding SMS messaging to your collection strategy, you improve the likelihood of having your message delivered through the following statistics. And these are just some statistics on cell phone usage and SMS text. Over 90% of cell phone owners have their mobile phone within reach 24/7. And don't know if you can see this, but of course I have my cell phone, I guess, as probably everybody does nowadays. Just kind of tied to one more thing we have to carry around. The text message response times are 90 seconds versus 90 minutes for an email. And while I try to get back quicker than 90 minutes on an email, sometimes it does take me that long. But I can tell you I do respond to text messages much quicker. It's just me personally. So mobile open rates are 97% compared to 20% for email. Again, you're much more apt to open a text message than you are an email. And the average user looks at their cell phone 150 times a day, which it makes sense. I can't tell you how many times I look at my cell phone per day. So the SMS messaging is very useful, and it will hit your target audience. Next message, or next slide. So a little more on mobile statistics and SMS. 96% of companies currently using or are planning to incorporate mobile strategies. 80% report and intend to raise their mobile budgets in the near future. And 84% of companies use mobile websites, 78% use mobile search, 76% of companies use mobile apps, and 75% of companies use mobile display ads. 42% report an ability to prove return on investment, and 96% of the U.S. population are cell phone subscribers. I assume that percentage rate is to those who are old enough to have a cell phone, obviously. 25% of U.S. households rely solely on their cell phones. According to a cell phone trade industry, 2.27 trillion text messages are sent every year in the U.S., which is 1.3 billion per day, or about 20 text messages per person every day. I assume, obviously, some people send more text messages than others, but it's, there's pretty significant numbers in as far as getting through to your target audience, or your target debtors in this case. Next slide, please. So I'm going to kind of loop back to the FDCPA here again before we get into the content of an SMS text message. And remember, 1692 requires the debt collector to stop communication, if a consumer requests in writing that the debt collector cease contacting them. The language, again, has been interpreted to require a written cease and desist letter. Again, I don't think that's going to be a stop response to a text message. No case law on that yet. 1692S states a debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt without limiting the application of the foregoing. The following conduct is a violation of this section. So these would be, a violation of that section would include causing charges to be made to any person for communicating by concealment of the true purpose of the communication. Such charges include, but are not limited to, collect telephone calls and telegram fees. Next slide, please. Now, obviously, for the most part, collection calls are a thing of the past, and telegrams. I've never sent a telegram in my life, and not exactly the youngest person in the world. So those, I think, are completely a thing of the past, obviously. But the FDCPA likely will interpret communication costs associated with the receipt of SMS text messages. So I think they'll make an analogy, obviously, between collection calls or telegrams to SMS text messages. So in keeping with this, the debt collector should reveal to the consumer, in very express language, that there may be a charge associated with the receipt of the text message. My cell phone just went off, so I checked it. Next message, please. Or next slide, please. So there's things to consider when developing your collection SMS message. Are you delivering a one-way or two-way text, meaning can the person respond to it? The law still applies to these even though you are not delivering a voicemail. So you're going to have to incorporate your mini Miranda into the text message. If a debtor replies stop to a text message sent by a debt collector, as we discussed, the debt collector should cease contacting the debtor through SMS. So that would be a strong argument to, refrain from sending that particular debtor, any further text messages. It's a likely defensible position for a collector to continue contacting a debtor except via SMS, who has merely replied stop to an SMS text message rather than stop all communication with me. So also you want to include in your SMS text message that standard message and data rates apply, or message and data rates apply. So that's important because you're advising the debtor that there may be charges for this, and also giving them the option to stop receiving text messages because of that. Pardon me. Nowadays, I think more and more, I don't have any statistics on this, but I would think that more and more people have unlimited text message capability on their phones, but I do believe there are still some plans out there where people are charged by the text message. So one could make an argument that they are being charged for the text message. Next slide, please. So here's a sample SMS text. It includes the rates, the stop option, and the mini Miranda. So the SMS text will have to come in part 1 and part 2, because from my understanding, the SMS text can only take so many characters, and we'll need 2 to do it. This is a message for Mary Smith. This is ABC Collection Agency. This is attempt to collect the debt, and any information obtained will be used for that purpose. Please contact the telephone number. Message and data rates apply, and stop if you want the text messages to stop. So there we incorporate everything: who the message is for, who it's coming from, and what the purpose of the message is for, and also that message that rates may apply to this, and obviously the contact information on who to contact. Next slide, please. So ringless voicemail marketing, this is an interesting concept. It's a system which deposits a pre-recorded message into a mobile phone voicemail box. The most defining feature is that the system will deliver the recorded message straight to the voicemail without ringing the phone. Some statistics on this: almost 85% of calls never reach a live person and end up in a voicemail. And most collectors can only make 50 to 70 calls per day. That is if they are manually dialing. Next message, please, or next slide, please. So again, to circle back to the FDCPA, how it will likely or may apply to ringless voicemails, the FDCPA defines a communication as the conveying of information regarding debt directly or indirectly to any person through any medium. So it's very clear that no matter how the emerging technologies, what new ones come out, or things that we have that aren't even available now that frankly are probably come in the future, through any medium the FDCPA will cover it. So while this is a new medium of communication, ringless voicemails will likely be considered communications that will be subject to the FDCPA's disclosure requirements and the prohibition of revealing information about a debt to third parties. Next slide, please. So here would be a sample ringless voicemail. And again, these are, as far as the ringless voicemails go, please bear in mind that these are just these are collection-oriented voicemails. So this is, strictly to the collection, to a collection call. I could, read this over again, but essentially it's the same exact message as you would leave on a voicemail where the phone rang. So I probably could, spare you me, going through the collection message again. But again, it's the same thing, and that would be the recommended message to leave on a ringless, if you utilize the ringless voicemail technology. Next slide. So just to sort of circle around, the use of new technologies to communicate with debtors has become increasingly popular, and industry commentators have noted that debtors may actually prefer to have collectors use these methods to contact them. They may be a more convenient medium. It's SMS text is quicker than opening up a letter, and they could prove to be very, very useful in collecting on your portfolio. So next slide. There is my contact information. If any of you would, in attendance, would like to contact me, please do. Take your call immediately and discuss your needs about collections, anything else you'd like to discuss. My firm and myself we handle a lot of Consumer Financial Protection Bureau investigations, and we know this. Obviously, the CFPB have kind of sunk their talons into the collection industry. So we're very well versed with CFPB, and if you have any questions or anything of that nature, please don't hesitate to call me. And Adrian?
All right. Thank you, Chris. That was excellent. I know I sure learned a lot. Now I guess we're going to open the floor for questions. So just a reminder, everyone, you can still submit your questions. We're going to still be taking them, but I see a few that have popped up already, which is fantastic. So let's go ahead. First question, Chris, for you is, in attempting to contact the consumer, you reach a third party. Can the debt collector leave a message including a callback number with a third party?
Yes. In that case, the debt collector, if you reach a live person, you don't want to disclose the debt. You can say, please contact me for important, please have whoever your debtor is contact me for an important business matter, and have them call you back. So it's with the messages that you want to give the whole disclosure. But if you reach a live person, you don't want to.
Right. And along those lines, too, you discussed that the FDCPA states that you can't harass a person by causing the phone to ring or engage a person in conversation, but does ringless voicemail fall under that jurisdiction since the phone doesn't ring, or is that a little different?
Well, that's a great question, and I think the ringless voicemail is going to fall under the same thing as if the phone rang, because while technically, obviously, the phone does not ring, you know, they're still getting contacted by you. So because it's ringless, and you know, technically there's a portion of the FDCPA that says not causing the phone to ring constantly. I would not recommend leaving more than you know, what the case law suggests, which is about 2 maximum per day. Because if you leave 5 or 6 per day, no matter how compliant those messages are, or how pleasant one sounds when leaving the messages, I definitely think, you know, you would open yourself up to some liability on a harassment FDCPA claim because you have contacted the debtor over 2 times per day. So, you know, again, sort of the theme of the whole presentation, same rules, you know, not excessive voicemails.
Absolutely. And as you just talked about prior consent, does that have to come in certain forms? Like, how do you get this prior consent, essentially?
Well, you're not going to need prior consent to contact a debtor who, generally speaking, who owes you money. So it's not, we're not in a marketing situation where you have to have an opt-in for them to contact you. You know, it's a good idea to have it written in the debtor's original agreement or original note, I should say, promissory note, saying, you know, he may be subject to being contacted if he doesn't pay, which it is, you know, and that's very general terms, like I just said, but which is in many notes. But generally speaking, you're not going to need permission to contact a debtor. My screen just went dead. Oh my God. Are you there?
Oh, I can still see you and hear you.
Oh, okay. Hold on one second. That scared me. My screen went dead. And hold on.
Don't worry, you're still here. We can still see you.
Great. It was my. I haven't touched my mouse, so it locked. But I'm sorry. Go ahead.
No problem.
Technology.
I know it does play with you sometimes.
It does.
Let's see. Another question just came in. Mobile phones can be work phones. If the collector doesn't know that it is, would that be defensible?
Yes, it would. Absolutely. And that's a very good question because, and I've seen some, you know, recent statistics. I don't know. I think I may have read it in the Times or the Wall Street Journal where companies are it hasn't happened here yet, which I'm grateful for yet, but they're encouraging their employees to use their cell phones as their essentially as their work phone. You know, as many people use their cell phone as their landline. So basically companies are getting wise to that and they can save a lot of money, and I'm sure they reimburse their employees by paying for their cell phone bill or however it works. But that's a great question. And the answer to that is I don't believe you could be construed as calling an employer, especially if you know it to be a cell phone and it's not registered to a company name. So I think you'd have a very defensible position if you were facing a lawsuit saying, you know, you contacted a debtor knowing it was their work phone number. And also you'd have to say, you know, according to the FDCPA, which we saw, the debtor, the collector would have to have knowledge that the debtor's employee not only is their employer, the debtor's place of employment is not only their employer, but that they don't accept calls, they don't allow calls to their employees. So I think you'd have a very defensible position in a situation like that. But it's a great question because cell phones, you know, they're so convenient and they're just you know, eventually probably going to take over pretty much or take a big chunk out of life.
Yeah, I mean, I don't even have a landline anymore, so they're definitely.
And I probably started doing that like 10 years ago. So, nope.
Great. All right. So we've got another one. You said that if someone replies stop to an SMS message, that you only had to stop that contact method. Is there case law, or is that your interpretation?
No, that's my interpretation. So again, if I would, as we said in the beginning of the disclosure, please, seek independent legal advice on this. But to the best of my knowledge, there is no case law on that yet. So, but I think you can make a very defensible argument that says, a stop merely means stop texting me, rather than cease all communication with me, and you would have to cease communicating with the debtor at that point. So, but as far as I know, there's no case law on that yet.
Excellent. And then, do you advise using text messaging and Ringless together to attempt to reach a debtor?
Sure. I mean, you can. It's similar to the same concept of writing a collection letter and calling the debtor. With those, I would, because we know when they're going to reach the debtor, and we know that it's, we simply know that versus a letter, I would not advise going over 2 per day on either of them combined, frankly, to be on the safe side, because if you go over 2 per day to 2 communications, which I think you could, a plaintiff's attorney could make a good argument that if you go over 2 types of communications that the debtor is going to receive on their cell phone, then you could be maybe face a claim for harassment, pursuant to the FDCPA. So to answer your question, yes, you certainly can use both, but I would use them as the same, with the same, along the same parameters as you would, say, using a telephone call. Frankly, I wouldn't exceed 2 a day.
Right, that makes sense.
Yeah.
Let's see. Oh, they just keep coming in.
Good.
You're answering great. Does the
right.
opt-in feature for text messaging provide a good defense?
Opt-ins. Well, the opt-in is going to be more in a marketing
Right, which you
segment.
touched on earlier.
Yeah, exactly. Opt-ins will, very generally speaking, opt-ins are used to contact, and again, this is out of the collection, completely out of the collection forum. Opt-ins are usually used to allow a telemarketer to contact a consumer, not a collector, that will appear on a do not call list. So an opt-in is where the consumer affirmatively states, yes, it's okay to contact me, even though my number's on a do not call list. So when the telemarketer contacts the consumer can't come back with a do not call violation. So that's where sort of opt-ins come into play, if that answers your question. I hope it does.
Yeah, that's a good clarification. So let's see. Oh, this one's for me. I guess I can answer this one if the slides will be available at the end or a recording. There is going to be a recording. This presentation has been recorded essentially. So it will be up on our website, and the slides will be available after the presentation. So Mark, I will be able to send them to you, don't you worry. And I think, oh, nope, I thought that was it, but no, we've got another one. Do you agree that if the collector follows the letter and spirit of the FDCPA, it does matter what medium one uses? One has to use common sense.
Well, yeah, if I understand the question correctly, yeah, you do have to use common sense, and I think you need, obviously, to follow the FDCPA and using these new technologies. They're new technologies, but there's not that many differences in it. You're still either contacting someone via a message, a voicemail message, or through written word. So, in summary, you want to take the FDCPA or whatever state FDCPA you may be dealing with, if you will, and sometimes they're called different things in different states, but and if they don't address these types of technologies, then obviously you want to do your best to conform what you're doing to the technology they do address, which is similar to the one you are using, if that makes any sense. So yeah, I would use the FODI message, do the mini Miranda, and that will certainly give you a very defensible position. Nothing's foolproof. Those of you in the collection industry, there's you probably know there's a group of plaintiff attorneys out there who they sue debt collectors. But if you follow the FDCPA as best as you can, I think you'll certainly have a very defensible position.
Absolutely. Well, looks like this brings us to the end of our presentation. I just wanted to thank you again, Chris. This has been great. It's been really informative. And just as a reminder, everyone, there's Voice One's contact information. Feel free to call anytime with any questions you may have about messaging. And feel free to call Chris. What's the best way to reach you, Chris? Either would you rather people call or email or?
Well, they can send me a text message. I'm just
Fair enough.
My direct number is great. That runs right to my desk. If you ever have any questions, feel free to call me. If you ever need any compliance reviews, myself and my firm are well equipped to handle that. We handle class action lawsuits. We have an entire litigation department of our firm. 150 attorneys, big firm. So please don't hesitate to call me directly, and I'd be glad to talk to you about any of your needs.
Great. Okay. Thank you so much, Chris, and we'll see you. And that concludes our presentation.
Well, thanks, Adrienne. Have a good day.
You too.
Okay, bye-bye.